Time. I'm Chris Irons, Strata Consultant, Hines Legal, former commish, body corporate community management. With me, as always, Frank Higginson, partner, Hines Legal. Frank, welcome.
Hello, Chris. Hello, everyone. And hello, the people that are posting where they're coming from sunny places. I don't think it's that hot up here today, Chris. I think it's balmy.
Today's much better than it was earlier in the week. It was
And where's the
rolling.
little trick we had with our names?
Oh, yes.
Chris has got a new trick, everyone. Watch this. Oi.
Just in case
Oi.
you don't know who we are or forget partway through the broadcast, a little reminder for everyone. As always, make sure you are subscribed so that we can get out to you what our webinars are going to be like, probably for the rest of the year, actually. We'll get that out shortly. If you've got a question today, put it in the live chat. We'll do our best to get to all of those. I think we got through a heap last week, but if your question's more involved and it's got a few more details, you're much better off putting your details in that link that's now showing up in the chat function. But look, we love a good sequel here on the webinars, and it's another sequel today, Body Corporate Debt Part 2. So we did this back in August, and unsurprisingly, given it was about money, a lot of feedback, a lot of questions, a lot of comments. We've had a lot of incoming inquiries since that time too. So today, Part 2 of the series, and today, Frank, particularly debt recovery, the process.
It is. So, and we're probably going to do, well, we've actually gone to our inner actors, I suppose. We've got a little bit of role playing going on, which could be quite entertaining for some of you and probably Groundhog Day for others of you, but we'll see. Yeah, so it's probably a little bit reinforcing what we said last time with a little bit more detail and talk about the actual recovery process itself. But more than anything else, we're trying to get lawyers out of jobs. Believe it or not, it's a lawyer saying. So we're not here, hopefully, driving people to start suing people for levy recovery, but to actually help them resolve their issues before they need to do that. So the reality is, unfortunately, that sometimes some people aren't going to do what they've got to do. That's the reality. But I think the default position for some bodies corporates is just the moment it's overdue, go for them. And that's not necessarily the right way to do it either. So the role playing we're doing today is really, I suppose, helping committees / body corporate managers / people in charge of recovering levies, how we think you should deal with some of those situations that you're going to get. Because the reality is people haven't paid. They haven't paid for a reason. And that reason might be some of the things we're going to do today, or it might be more.
And look, these webinars are body corporate content. They're also a little bit of legality. They're a little bit of common sense, and they're also quite a bit of communications skills. And we actually think that when it comes to this topic, debt recovery, because it is such a trigger for people, there's an element of honing communications skills. So, for example, think about it, put aside the body corporate side of things. If, say, for example, Frank, I owe you 10 grand, you ringing me and saying, where the bloody hell's my 10 grand? I want it right now. That's unlikely to get the same outcome as you ringing and saying, look, it's been a little while. What's going on with the 10 grand? Where are we at with it? There's a big difference, isn't there?
It is. And it's funny, these things, like they're life skills you don't learn other than actually until you're owed money. One of my very first job when I went to London, working in a minicab company, which is, I suppose, Ubers before there were Ubers, and had a whole heap of corporate accounts. So my job was, amongst other things, to ring the account holders who were overdue and chase them. So we had to ring an ITV celebrity one day, and I got her in the back of her own limo. So like brush with fame. But yeah, it's sort of the manner of doing that is it teaches you a lot in terms of how to deal with things. And I think one of the difficulties or one of the issues with levy recovery for me is they can be difficult conversations, but someone's got to do them because if you don't, and you just fire it off and you go nasty legal early, and the process, and there's a couple of you that are waiting for flowcharts, which are almost there in terms of what we think the ideal levy recovery process actually is. If you go nasty early, it just really descends into that tit for tat email or ignore things, and it doesn't actually get you an outcome. And particularly, I think, when things are just laid off straight to lawyers, because the reality is debt recovery at its core, particularly the initial stages, is not highfalutin legal work. So it tends to get passed down right to the lowest level, sort of, and I'm trying to be disrespectful, junior staff, not senior staff. So you're not going to get someone like me ringing a debtor, say, mate, come on. It goes down to junior lawyers who haven't necessarily learnt the skill set yet and the nuances of dealing with those difficult conversations, and that can actually set the tone the wrong way. So part of this is helping what we think people should be doing before it even gets to that stage, because lawyers at the core aren't necessarily the best communicators.
And
depends.
And Frank, there's a long-term benefit for that approach too, because if your enhanced communication at this stage can get some breakthrough, or at least doesn't make the situation worse, then for other body corporate issues that come up in relation to that owner, chances are you have set the scene for some better relations moving forward. So,
and mate, how often have we seen the disputes that we get are about this, but they started over here? And absolutely, over here is where these things can be the genesis of World War III. Because if you want to have a chop at someone, they get the chance to have a chop at you, away you go. Handled differently. And this is part of the pain. Body corporate managers get a lot. They're subject to who you're with. They might have recovery teams. And it might even come back to the role of committee members in the sense of self-managed schemes or where they want to do it themselves. It's a difficult thing.
It is a difficult thing.
Handled right, communicated right, it can save you a whole lot of pain, because dealing with litigation is a separate story entirely, and we'll, I suppose, finish with that.
We are. So we are going to do the actual litigation side of things, but first, role play time. So we've chosen what we think are three of the most common owner types that a body corporate, a committee, body corporate manager, or indeed a lawyer are likely to face in a debt recovery process. There are many other types of owners, but these are the three that we think are most common. And we're just going to go through what we think would be the usual things said in those kinds of conversations. And then we're going to try and derive some very basic, quick learnings out of each of those. So let's kick into it with Oscar-winning style, no doubt. So first up today, angry owner. I know everyone out there is going, is there any other kind? There are. But first up, there is angry owner. Frank, I believe you're the angry owner in this case.
I am the angry owner today. So, mate, I've got this $5,000 invoice, and what on earth is that about? You blokes are a bunch of thieves.
So, Mr. Higginson, is it?
Yeah.
Yeah. So I'm guessing that what you're looking at there is the levy notice. So that's what you owe in body corporate levies at the moment.
I don't know what I'm looking at, mate, but I've got a nasty letter from you blokes telling me it's $5,000. There's $1,000 worth of interest, and there's these bloody recovery costs there. And I don't know. It's the first I've heard of it. Like, what is this?
So maybe then, do we have your email address right? Because if you haven't been,
you tell me. It's on your system.
That might
what have
be
you been sending it to?
That might be something we should check in this call, because if you're saying that you haven't gotten the notices before now, then maybe it's not going to the right place. So we can check that. But look, in answer to your question, the levies are what you pay as an owner as your contribution to the body corporate expenses.
So these are the driveway that out the front that's not fixed. The fact that my roof leaked last week, isn't that your problem? I'm paying money to come to you blokes, and you're not actually doing your job.
Yeah, so you pay money for the upkeep of common property as part of body corporate expenses, and what I mean by body corporate property is everything that is not your individual property. So the driveway is part of the stuff that your money goes towards in this case.
Sounds like rubbish to me, but I mean, you've given me so I've got this invoice. I've got all these add-ons. What happens if I don't pay it?
then the actual formal debt recovery process will kick in, and that might involve some legal action.
But I paid council last week.
Yeah. So council is totally different to body corporate levies. They're two separate things.
Well, don't you both do rubbish?
No, council does rubbish.
So I still don't understand, mate. I can't get my head around the fact I've got $5,000 that I owe you blokes.
Would it help, Mr. Higginson, if we sent you out some information about how levies are calculated? Would that help?
It probably can't be a bad idea, but let's just make sure you got my right email address first this time, eh?
All right. So we've got here on file angrybloke@hotmail.com. Is that the right one?
That'll do, but I don't check it all that often.
All right. Well, that's good to know because that's how you'll get notices from us. So if you're not checking it, then that's probably explaining why you haven't gotten the notices before now.
Right.
And we might wind it up there.
Yeah.
Um,
I'm trying to smile and look angry at the same time.
Yeah. That's a tough one. So what do we learn out of that? I kind of tend to think that anger in this kind of scenario is almost a given. So it's not about saying it's wrong to be angry. I don't know. What do you think, Frank?
I think you probably got to roll with it sometimes. You know, it's one of those things that if I'm ringing you and I'm unhappy, like there's plenty of things that I suppose we've all got to do in our daily lives. We've got a $5,000 invoice, got the shits with it. So I'm in an unhappy place to start with. So sometimes, and this is the unfortunate reality, and we cop this as professional advisors as well, sometimes you're a bit of a punching bag.
Yep.
Right, wrong, or indifferent. You're dealing with unhappy people who might not actually understand what it is they've got going on. And this is, again, what these webinars are really about, sort of the ongoing educative process for people in strata communities to help them understand what it is that's going on. You know, and mate, same thing. We just come back from Strata, the latest Strata title working group this morning, talking again about seller disclosure in terms of what information sellers need to give buyers, and whether it's going to make a difference. Are people going to read and understand what a body corporate is? Because there's always going to be those people that don't. So
that's right. And that kind of leads to point two, which is that you've got to know your limits, particularly when dealing with someone who's really sort of angry or potentially abusive. You've got to know where to draw the line on that. So if you're working for a firm, no doubt you'll have internal policies about that, and you'll know where that gets cut off. I know that in the Commissioner's office, when I was Commissioner, we had I put into place some pretty strict policies about how much we'd cop from individuals who would ring the office. And indeed, after a certain point in time, some people got on the banned list. So you do need to know the limits at the end of the day. But I think the other thing to emerge out of that, Frank, as you said, was the educative aspect of that conversation. So much of anger, certainly in my experience, when it comes to strata, derives from lack of knowledge, ignorance, just not knowing. And you could hear it in your voice. I don't know what this is. So that's making me angry, and I'm then projecting that anger onto you. So it's about addressing, we're big on this one, it's about addressing cause rather than effect. Bit of effect, but emphasis on cause.
Yep. Okay.
Shall we try number two?
Try number two. Number two. So this is the confused owner, and Chris is going to be the confused owner.
I can do
I'm going to be the
confusion.
helpful person at the other end.
I can do confusion. Ring, 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 ring. Ring, ring.
Oh, hello. Hello. Can I help you?
Oh, hi. Yes. Is that the body corporate?
Yes, we do manage bodies corporates. Do you know which one you're calling about, sir?
Yeah. We're 6 stories.
Cool. Have you got a street address where you live? Because I might be able to track you down that way. What's your street address?
Oh God. Yeah. Smith Street.
Cool. Okay. Well, anyway, we'll get there in a minute. What are you ringing us about today? How can I help you?
So I've got this email, and it says I owe $5,000. What's that?
That surely has probably got to be your body corporate levies. So that's the levies. That's your share of the cost for that 6-story building that you're living in.
So it says on here that I've got to contribute some money to a sinking fund, but my building's not sinking.
It's not the Titanic. No, see, that's a
No,
mistake. I shouldn't be doing that because that's not helpful in
that,
terms of
that
building
that's
our
that's a
relationship
good
with you.
point. That's a good
Yeah, no,
point.
no, absolutely.
Mm.
Well, so it sounds to me, how long have you owned this unit? Have you been there long?
No, look, I only owned it. I've only owned it for about 3 or 4 months.
Cool. Okay. So probably you're like many people that are new to unit ownership in that you probably don't necessarily understand the nature of what it is that you bought into. So if I can get your name and address, probably the starting point is that I can send you some information for you to have a look at and send you some helpful resources like a thing called the Commissioner's Office that's run by some very friendly people called commissioners from time to time. Um,
Oh,
and you can do some reading up there, but so you can understand what it is that you're actually in. But I can tell you now is that that invoice you've got is going to
sure.
be for the costs of looking after that building as a whole. So the admin fund is for what, things like insurance and that sort of stuff that happens every year because you don't need to pay insurance for your individual unit. The body corporate pays it for you. And then the sinking fund is for things like long-term capital repairs and things like that, like the lift. So the
But
lift's
but
going to need to get replaced in due course, and that's what that money's for.
but the bloke I bought this apartment off didn't he pay for all of that?
He probably would have paid for some of it. So what would have happened is hopefully, that's what I asked you, do you have a lawyer act for you? No, I acted for myself. Great. No. Now, hopefully your lawyer or your conveyancer that did the purchase for you normally would have done things called settlement adjustments. So what that means is that you would have got a contribution from the person you bought from towards that levy invoice that's in your hands. And that probably would have been adjusted in your settlement price. So probably your next call should be to your lawyer, or even check your email or the documents your lawyers sent you, because the settlement adjustments and their final letter to you should explain to you what's happened. And the same thing will happen with your council rates.
This is crazy. I don't
Yeah,
understand any of this. And we'll
I know.
probably stop it
Yeah, no.
there.
And look, you're
Yeah,
not alone. Like even
yeah.
for me, and I live in this industry, it's confusing from time to time. I'm not
Well,
trying to be patronizing here.
that's an interesting ploy there, Frank. Good moment to pause. Introducing a note of empathy. The only thing I'd say about empathy, again, in my experience, is that can encourage more rather than less. And sometimes you don't necessarily want more, so you just got to strike the right note of empathy. I think that one was actually okay. That one, because
Oh, good.
there's a bit of we're all in this together kind of stuff. So I think that's okay. So what
Yeah,
else
and
do
see,
we?
I'd call that identifying with someone.
Yeah,
Same thing,
yeah.
really, though, isn't it?
Yeah, it
Yeah,
is.
yeah.
It is. So in that one, we've got a scenario in which the person who owes the debt comes from a position that's way, way back. So it's not even about refusing to pay or anything like that. It's actually not grasping the most fundamental concepts. And it might be that someone in that situation comes from a disadvantaged background or has some kind of medical condition that doesn't make
Oh,
it easy
start
to
with English
comprehend.
as a second language, because then it even
Hmm.
gets harder having that conversation.
Yeah. So if you're starting to pick up on any of those things, very carefully, if you can find out that that's one of the issues, there are then ways you can address that aspect of it. But I think, Frank, it's largely the same as the first scenario, isn't it? There's a very strong educative process up
Mm,
to a point.
mm,
Yeah.
Up to a point, that's absolutely right. And this is where just firing off nasties in emails and not actually picking up the phone, as annoying as that is going to be for someone,
Sure.
um, because it's a whole lot like that confused owner is just going to ignore stuff from the body corporate. There's more confusion. The old, I mean, we've all got things we don't want to deal with um, in some way or another. So they just ignore it.
Yeah. Deny, deny, deny.
Mm,
Um, let's move on to our final scenario, Frank. You're back as the owner this time,
yep.
and this one is the emotional owner. So
And
we'll
I'm not
give this
good at
one a go.
crying, but Australian male, but I'll do that. Ring,
All
ring,
right.
ring, ring.
Ring, ring. Irons Body Corporate, how can I help you?
We're not doing, no. Mate, I got a levy invoice here for 5 grand and I just can't afford it. I,
Oh,
I, I, I,
okay.
I don't know what to do. I got laid off 2 weeks ago. You know,
Oh,
I got to keep food on the table. I don't know what to do with it.
Yeah. Okay. Okay. Oh, look. I mean, I'm sorry to hear that. Let's have a look at what can be possibly done in this situation. So, okay, you've got your notice there for 5 grand, and you're telling me that you can't possibly take care of that by the due date.
I just don't have the money, mate.
Okay.
You know, I
Okay.
don't like not paying bills, but I just don't have the money.
Okay.
And
Okay.
I don't know when I'm going to have it.
What about paying it off in installments? How might that work for you?
I can probably wear some of that, but how much?
Well, we
And
can.
what we're going to do is, like, there's a threat here saying you're going to get interest and lawyers onto me and all that sort of crap, mate. So that's just going to add up to more.
Yeah. Okay. Well, on the issue, sorry, I'll go back a step. So look, we can set up an installment plan. It's about what you can afford, because at the end of the day, some contribution is better than none. So maybe what we can do is you can drop us an email, and you can say, or what I might do after this, I'll send you an email and I'll ask you to tell us how much you think that you can afford under that situation.
Cool,
Does
mate.
that
That'd be
sound
appreciated.
okay?
Yeah, that's good. Thank you.
Okay. So we'll cut it off there. Obviously, there'd be a lot more tears in that situation. And again, we've all been unfortunately, on the receiving end of that kind of call. Probably one of the things in that scenario, Frank, and we didn't quite get to it in the call, is the idea of special circumstances.
Absolutely. So the legislation actually does have a degree of empathy in it. So, you know, what levies, body corporates cannot waive levies. Let's make this subject to current COVID regulations, in which case they can refund some sinking fund stuff and all that sort of stuff. But as a general rule, a body corporate can't waive levies. What it can do is waive penalty interest and reduce recovery costs, and it can extend time for payment if there are special circumstances. So those economic ones are clearly those sort of things. And obviously there's going to be personal ones. You know, I've just been in hospital, mate, for a month. You know, I can't go back to work, etc., etc. So it is well and truly within the ambit of a committee to do those things, to
And I
waive.
think, Frank, correct me if I'm wrong, it's actually weighted towards the committee doing that as opposed to not doing that. That's the way adjudicators have tended to look at those scenarios. If somebody can establish, like that example you just gave, I was in hospital for the last month, therefore I had no capacity to receive a notice, let alone do anything with it. If I have presented you with that and some evidence of that, by the way, it's fair enough to ask for something to rationalise that. It's pretty difficult for a body corporate to refuse to waive those special circumstances.
Yeah, well,
There.
it's back to that acting reasonably, isn't it? So I've been sacked, and the government and the legislative intent before the COVID regulations was absolutely along those lines. People could claim hardship, and the body corporate was prevented from doing it. So the choice was taken away. And this is again that element of community, not just sparing people for sport.
That's right.
You know, so it's not unreasonable, I think, to ask for some sort of evidence gently. You know, my wife just kicked me out of the house. I don't know how you prove that sort of stuff.
There are some things where you're just going to have to take the written statement, I would have thought, but there are some things you can evidence. A termination notice is one of those, for example.
And I
The
think the key
hospital
thing
bill
is
would be the other.
the consistency. Whatever the committee's doing with those special circumstances, it should really be consistent. So it's not one rule for some and one rule for others. It's trying to have a consistent policy or approach as opposed to a blanket set of rules. So, you know, 3 people roll up with the same roughly set of circumstances, giving 2 of them leniency and belting the other one probably isn't appropriate.
Good point, Frank. Let's rip into the balance of our. So we went through the role plays. Yeah, Oscar nominations, no doubt, on the way. The formalities then, Frank.
Yeah, and I
Formal
suppose try not to do the legal stuff, but I mean, a levy recovery proceeding is no different to any other court proceeding. In that sense, you actually file a claim, you've got to lay out, and this is one of the things that people, if you're going to sue for something, you've got to, it's not just you owe me 5 grand. you owe $3,433 in principal, which is the levies. You owe this in recovery cost. You owe this in interest. This is how it's calculated. This is the amount on which it's going to accrue, et cetera, et cetera, et cetera. Of course, one of the things with levy recovery is that if you're commencing a state proceeding, you're serving it in another state. There's a regime that runs around that, and of course, lot owners aren't always in Queensland. And then the whole process runs the same as any other sort of formal proceeding in terms of there's a notice of intention to defend from the person to the extent they're going to defend it. Then they file a defence. So where levy recovery itself probably runs up to can be automated to a degree up until you're actually commencing proceedings. Well, not automated, but it's not as thinky. But the moment you've actually got to file a claim, and even for us, where we start is when we're dealing with these things, our first role is to make sure that what the client says they're owed is actually what they're owed, because systems and software can calculate things incorrectly.
Yeah, definitely.
And so if you go and commence a proceeding and you sue for an amount that's wrong, a defence to that claim is going to be that you don't have the statutory entitlement to recover that because of. Now, it doesn't necessarily mean that you can't recover it if you go back and rejig it the right way, but that could be 6 months later. So getting it right from the get-go, and then once someone files a defence, and the defences can include things like, well, you haven't fixed my roof, you haven't done the driveway, as much as they're not going to stand up. Yeah. That's like full-blown, and then you're into full-blown legal proceedings. So there's a couple of links that Chris will put up there. One I wrote about there, I think the wave. I wrote about this probably a decade ago. The claim was $6,000, and they spent 300 chasing it. So and that does my head in, because if I had a client come to me and say I'm owed $6,000, and I said to them, sure, you're going to spend $300,000 chasing that, they're going to say no every time. But this body corporate charged on and did it.
Absolutely. We've only got a few minutes left, and we wanted to do a bit of takeaway, and also we've got a few questions there to address.
I mean, the
Frank,
takeaway,
really, I was going to say, Frank, really quickly, you've kind of touched upon this, but the commerciality of litigation. It's
got to be worth it. So, like, it's a very rare statute that obliges someone to commence proceedings, and that's what happens in BCCM in terms of you've got 2 years and 2 months to commence a proceeding once for an amount once it becomes overdue, which is stopped during the COVID period. So we've got that COVID regulation that extends the body corporate's rights or obligations to commence proceeding until April next year. Mm-hmm. But after that, when we eventually go back to whatever the new normal is, body corporates have to sue. It doesn't mean they have to sue vigorously. It doesn't mean they have to prosecute things to the extent that Genghis Khan actually would. And sorry, my phone is ringing, and I will just kill that off there. So you don't need to go as hard as you like, because the other thing that happens is interest actually accrues on body corporate levies at 30% per annum, 2.5% per month, not per year, per month. So in some senses, subject to where debts are and all that sort of stuff, if owners, and we get quite a few of these where owners are actually, we get engaged by bodies corporates to talk about recovery for larger amounts, and then the units on the market. My usual commercial advice to the client is have a chat to the owner, say to them that if it's sold in a month, we're all good, and there's no one going to be suing anyone else. That's actually a little motivator to do it, because why pay me $3,000 or $4,000 to get after someone when they're going to pay it back in a month's time anyway?
Yep.
It's just nuts. But that happens a lot.
Yeah, and this is where one of the fundamentals preached, we'll call it preaching, in this webinar series is that difference between thinking calmly, unemotively, and objectively versus thinking emotionally. Because the emotional thinking often, well, not often, pretty much always, leads you down the wrong path in the body corporate context, particularly when it comes to a monetary issue. Our very quick takeaways today, because we really are running out of time, it's largely the same as what we said last time, Frank, isn't it? Which is the body corporate needs money to survive.
Like, it's a business, like our business. We can't keep the doors open unless we do work, we invoice it, we get paid. That's our form of levies. Same thing.
That's it. So, and from the owner's point of view, you don't have any choices. You must pay your share. So there it is. And the body corporate must collect. So those aren't options. What is optional, potentially, where there does exist some elasticity, is how one goes about it. So there's no negotiation around timeframes. as an end frame. What there is flexibility about is the process. And today, I hope we went over some other ways of potentially approaching an issue from a different perspective. Let's address a couple of questions really quickly. Len, thank you.
Other than Glenn is saying she wants to see tears.
Yeah, well, we're not. Yes, we. It's one of the great skills of an actor is being able to cry on demand. I didn't pass my NIDA audition, so I can't do that. No, literally, I didn't. From Len, kind of a more general question. How do you deal with a difficult owner who you suspect may have mental health conditions evidenced by past actions with other owners? Great question, Len. One that I think a lot of people grapple with. If you want to go back and have a look at a previous webinar we did on what we call challenging people, we actually covered off on that in some substantial detail. You do need to tread very carefully.
Would you be able to put that up as a link, Chris, in the chat afterwards?
Yeah, we can do
that. Yeah, because we've covered that a bit, Len, because there's a fair bit of that goes on.
Take a look at that one. Gleno, as always, thank you for tuning in. Is a JP stat deck sufficient? I think you were talking about the special circumstances. I would have thought so, Frank.
Absolutely.
Yep. John, as always, John, thank you for tuning in. We've just been asked to hold off on BC fees for an owner who's died. The executor says the estate will cover the fees eventually, possibly after the unit is sold. How long is reasonable to wait? We've kind of covered that off, haven't we, Frank?
To a degree, and I reckon back to when I was being maybe the difficult owner, the confused owner, one of the things I think that's really important is not leaving open-ended dates on things. So, so to me, I'd be reaching out to the executor and say, mate, that's cool. We're not bloodthirsty hounds. We know you're dealing with loss, et cetera, not trying to be unempathetic. But by the same token, we've still got to make sure that things happen. So what's your likely timing for that? And just know that interest can accrue because, and Danielle, you've asked 30%, who chose that? The government did, believe it or not. It's actually in the legislation.
Yep.
It's not an arbitrary rate. It's been fixed that way forever. So it's a massive disincentive, particularly in this environment, to not pay.
Yeah, and back to John. John, that's where you can use the educative aspect of what we spoke about today and just reiterate back to the executor, this is not about being unsympathetic, particularly if it's a family member. This is not about being unsympathetic, but we need to know. And it can't be open-ended and indefinite. We'll need a commitment on that. And if the answer is we don't know, then that's probably not going to cut the mustard in that particular case.
And that's part of one of the things you can't do is assume responsibility for other people's problems. As brutal as that might be, this is a you problem, not a me problem. So don't make a you problem a me problem.
And if you wanted to be really cold about it, John, somebody should not be an executor if they're not willing to take on that kind of responsibility and that problem. That's being an executor actually involves. We have well and truly come to the end today. Geez, that one really sort of went to some interesting places today, but good places, I think.
Deep down into the well.
Yeah. Thanks, everyone. Just a note about next week. There will not be a webinar next week. Both Frank and I are otherwise occupied next Thursday with various bits and pieces. Lots of bits and pieces, actually. So, unfortunately, we won't be back on. Hopefully, you can manage without, though. Back on deck on the 21st. So, just reiterate that. Back on deck 21st, 2 weeks' time. And we're going to do Body Corporate Records Part 2, we think. And
we'll have out probably a lot more detail about what we're doing over the next couple of weeks as well. And that's a little bit behind because I was away last week. So scrambling a tiny bit, but hey, here we are.
Yeah. For now, though, thanks all. Frank, thank you.
No worries, mate. Thank you. And Kel, completely, just there's one last question there. Taking out a writ on the units, they advised they were going to sell, but aren't seeing the unit put up for sale. Sometimes you have to do what you got to do. But just the question, anyway, we've covered that. So again, thank you, Chris. Thank you, everyone, for the engaging comments and the feedback. I'll see you in 2 weeks.
See you all. Bye.
Okay, bye.